Michael Young was also going to be on a panel with Noel, and ostensibly we'll do that with some information that he's communicated to Noel to help answer some of the questions I will pose to him. Michael regrettably is not here because of the complications of the storm and the travel challenges that are associated with that. Michael regularly shows up on Accounting Today's Top 100 Most Influential People. He's a litigation partner in the New York office of Wilkie, Fair, and Gallagher, focused on securities and financial reporting and specializing in accounting irregularities. Serves as counsel to the AICPA and the Center for Audit Quality. He's also been on the FASB's Financial Accounting Standards Advisory Council. He's a frequent author on financial reporting and accounting irregularities. So let me start off. Noel, if you'll rise. By asking about confidentiality and whistleblowing. In your background materials, you'll find some proposed standards from the International Ethics Standard Board on responding to suspected illegal acts. We have seen international standards have a way of moving into the United States, which means serious consideration needs to be given to this proposal. The paper says an accountant does have a right to override the fundamental principle of confidentiality if one concludes that the suspected illegal act would have harmful effects to the public. First, Noel, if you would give me sort of a general overview or a whistleblowing for dummies, I'd appreciate that before I actually jump into the first scripted question.
Okay. Already off script, I see. Well, that's Dr. Allen to you.
There you go.
Well, obviously it's an area of interest and change. And I have some comments from Michael that I'll throw in later. But from the U.S. point of view, aggressive set of laws that promote whistleblowing, that reward it, that provide a bounty for it. On the international scene, those laws are in development. The crunch is that there is a bit of a gap between what is, and no pun intended, a bit of a divide between what is provided federally and what is required in states. You can literally, under current whistleblowing statutes, have a situation in which someone could, a CPA could be whistleblowing and be rewarded under federal law and yet not protected from a state board inquiry with regard to potential violation of confidentiality. And that depends on your state's laws and rules, but it's out there. It becomes more complicated in the international context, not only because you may have other standards that are applying, but you may be disclosing to an overseas entity that is literally, under the law, a third party. And so you've got some disclosure there. So it's a crossroads, some very fundamental issues. I think the overarching worry for the standard you have to apply and what you decide to do as far as balancing whistleblowing and public protection versus confidentiality responsibility is in part one where you're deciding whether or not ultimately a regulation or a perspective impairs the auditor's ability to get candid, accurate information internally from their client. And so there's a stress from that point of view as well. So overarching comments.
Continue with the whistleblower for dummies. So who would want to blow the whistle to?
Okay, well that is a sentence that ends in a preposition.
Oh, there's a good joke that goes along with that, but we'll leave that alone.
We learned that at Elon.
Yes. Man, I wish I could tell the joke.
Well, of course, as the federal law provides, the whistleblowing is something that you communicate to federal authorities. The standards expect, at least those that have been proposed in the international arena, and I think are there for the states, is do you first go internally to the client? Do you report to management? Do you explain that? And then if you don't get satisfactory communication from that form of whistleblowing, then you have to consider whether or not the act is such that you would report it to another authority. The definitions of authority get interesting too.
So can a CPA be a whistleblower in the United States today?
It would so appear.
Okay.
But some of it depends not only on the federal laws, but the state laws as well. There are a number of states that explicitly define confidential information and make part. Well, I came prepared. Well, no, he's not NASBA, so, but I'm wearing the white hat. He gets to wear the black hat.
I'm sorry, we tried to get Bill Cosby to come to take Michael Young's place, but the best we could do was get Noel to show us his funny side.
And Michael was good enough to send these when he knew that he was just not going to be able to be here. Flights were a problem. He wanted to be there with his family as the hurricane was hitting as well. He notes that one of the greatest dilemma for financial reporting is blowing the whistle. Particular dilemma for accounting profession. Investors have a sense that the accountants know what's really going on, and they ask, why don't the auditors just tell us? The approach of accounting professions not to blow the whistle, the core concept being confidentiality. And how do you reconcile the two? Auditors don't themselves blow the whistle, encourage that approach to call upon the client to blow the whistle. And then the dilemma occurs, what if the client doesn't? Faces a real dilemma. The expectation the auditors serve the public interest, and the expectation the auditors will blow the whistle when things are wrong. Under professional standards, he thinks that you just generally cannot. The result is an intricate dance in which we try to get the client to blow the whistle on itself. What is a legal mechanism? The laws are different, public, private companies in that regard. In a public company, the 10A report applies to possible illegal acts. Auditor is to evaluate whether a client is taking timely and appropriate remedial actions. If not, the auditor is to tell the audit committee. The auditor is then to inform the SEC. Notice doesn't call upon the auditor to blow the whistle, calls upon the auditor to encourage the company to blow the whistle. If the client doesn't, then you go to the SEC. Private companies, it's analogous to provisions in gas. It applies to possible illegal acts. The problem is there's no SEC to run to, so the auditor again tries to get the client to blow the whistle on itself, but obviously it's more difficult. There we are. There continues to be a significant risk for the accounting profession. The auditor knows there is fraud and the public does not find out. That can exacerbate liability for the auditor. Taking off my Michael Young hat for just a moment, and it's not fair that he would have a more cogent answer than I would, and I'm here. But I think that's a rub for us here in attendance, not just as practitioners that you are, but as regulators, and how the public is going to be protected. So worrying a little bit less about the liability point of view, I still, as a regulator, have to worry about what happens to that critical, delicate balance between the outside auditor and the internal folks that know something and need to be comfortable to be candid with the auditor. And what do you lose by turning your outside auditor into basically a government agent in that context? If something goes wrong, the public's not going to dwell upon those nuances. They're going to look at it, okay, you knew, why didn't the public know?
Let me offer, if anyone in attendance today wants to rise and go to the microphone and ask a specific question to Noel, feel free to do that as I continue as well. And as I do that, Bucky is rising, and I didn't know if he was headed to the men's room or to the microphone. It looks like he's headed to the microphone. Hey, all right. Oh, there's a race. Ray Johnson and Bucky. Go right ahead, Ray.
Noel, you talked about the situation, the words you just used. If the auditor knew. I think there's a question, and one of the big issues raised in this exposure draft is if the auditor suspects. How do you see auditors trying to resolve that difference? I mean, from the public perspective, if the auditor suspects versus the auditor knowing that there's an illegal act, is that a different situation, and how should we be looking at that as regulators?
I think that you're absolutely on the fulcrum of the dilemma that Mike was talking about that I would focus upon too. In legal terms, it's the knew or should have known idea. I'm not sure how far the law would go in terms of someone having reason to believe. There again, the international standards, if I could inject that, the proposed IESBA, those proposals. First, let me say this, if I may jump ahead into the international as well, because I think that the international takes that issue on a little bit differently, and that is that under current IFAC section 140.7, 140.8, as a general requirement that information remain confidential unless there exists a professional right or duty to disclose. And then there are specific examples where that right or duty might exist, and they sound fairly similar in terms of it's pursuant to in the course of legal proceedings or to appropriate public authorities, infringements of the law that come to light. In those instances, there's also a professional duty or right to disclose when not prohibited by law. That backdrop, again, comply with a quality review, to respond to an inquiry and investigation, protect professional interests of the individual auditor, as in the instance of their being sued, comply with technical standards and ethics requirements. But it goes on, and the Ethics Committee for IFAC has expressed concern regarding their code and its failure to provide any guidance for accountants who encounter fraud or illegal acts, who receive reports of fraud or illegal acts, and who report fraud or illegal acts internally within the company, and whose internal reports are not adequately addressed. So again, that's an active concern. There are specific country exceptions to all of that. The United Kingdom has a general position that disclosures of client information is required in some situations involving tax evasion, terrorism, and money laundering. There seems to be some logic in those exceptions. Some countries go to the other extreme, and some go nowhere at all in those concerns. The IESBA chair, Holmquist, has stated, when the consequences of non-disclosure are potentially harmful to individuals or society, confidentiality must be overridden. And that's the direction, at least, that the proposed changes go in. I think that that's where we get back into that definition, or trying to understand if you have reason to believe that there is illegal action. That would be one thing. And one suggestion is out there that you consult with a third-party expert. There was even a suggestion in the UAA drafts to consider consulting with that you first talk to an attorney. And I just love UAA provisions that build into themselves a requirement that you talk to a lawyer. But that's another way, really, of good faith trying to wrestle with that situation. Is it really an illegal act? You're sitting there and you have some idea of the response to that. At the same time, you may not have the information. What if you blow the whistle and it turns out that you were wrong, that it wasn't a potentially illegal act, that there was some unknown exception out there? We're going to be going through a period where, and I think the ante is up because the ante is up, and that is that, I'm sure most of you saw in the paper just within the past month, over $100 million bounty being paid for whistleblowing. And so there's just going to be more stress on the system like that. I note in passing that there are comparable whistleblowing promotion provisions in federal law with regard to federal employees, but not nearly the protections with regard to whistleblowing in that regard. So there's an inclination to encourage it in the public sector with regard to SEC registrants, but within federal government itself to not be quite so aggressive in promoting whistleblowing. I know I haven't answered the question because I'm not sure at this point it's answerable.
Bucky?
This morning we talked about that topic at the regional breakouts. And does the fact that the CPA may be compensated, sometimes quite generously, change or give rise to questions by the regulators as what was the motive? Was it the greater good or the greater income? And if it's the greater income, now that we know what we are, we're just arguing price. So, I mean, what's the motivation? And do we have to consider that if you have a whistleblowing case?
I think that bothers members of the UAA committee fundamentally. The thought that the trade-off against something that's very important, and not just to help you get clients, but to help you get the vital information so you can do your work. That confidentiality is expected and required. To suddenly trade that off against huge rewards that could be in there. The tough call is that, and I try to imagine in this way, what if a whistleblower came to me and I was evaluating the situation. In part, I'm looking at probably a federal law that is not only taking a public policy position of actively encouraging whistleblowing, but authorizing that big bounties be paid in that regard. It's tough to advise the CPA who is struggling as to whether or not they should be disclosing when you have a strong federal public policy in that regard, promoting the whistleblowing, promoting the disclosure, and then rewarding it on top of that. And it is the rub, it is the wrong, it is a problem because you are in effect rewarding someone from violating one of the very basic tenets of your professional relationship with a client.
So Noel, let me ask you. Where is Billy going?
I prefer to stand with my back a little closer to the wall.
Go right ahead, Billy.
That would be my legal advice.
Can I ask a non-whistleblowing question before Mark dismisses us?
You can ask anything you want to.
Thank you.
Doesn't mean we're going to answer.
Subject to that, can I say? That's true. Well, then this question is for Michael Young. attestation reports, which we've spoken about much, as well as this morning Barry covered it very well. My concern as a state board member, as well as a practitioner, is there some range of attestation reports where we as CPAs and we as regulators of CPAs as defined in our acts get a little out of bounds in regulating these attestation reports? Most conform with gas, and behavioral standards, attestation standards and behavioral standards. Once we move into the realm of just conforming to behavioral standards, do we begin to lose our right within our states to practice exclusively as opposed to practicing competitively? And is that a risk to the public as well as to the profession? My concern in Texas many years ago, we fought a case with American Express, for example, to protect the right for compilations to be considered attestation or attest reports. And so I'm very cognizant of the concerns that are there with the public. Had they been reports on internal controls or evaluations or some of the other things that we see a market demand for today, my question is whether or not we might have won that case. And or do we get to a point within attestation when we get further away from financial items, financial reports, financial statements, and the standards of a test, that we run the risk of being unable to regulate and or unable to opine exclusively?
Excellent question. In India, legal or professional right or duty to disclose is the only circumstance when disclosure of client information. Oh, that's not your question, is it? I'm going to take
a good answer from my end.
Yeah, I'm going to take a stab at it, Billy, because I think it is important, and I want to share that I think there's a commitment from the public protection point of view to consider that enlarging of the definition of a test. The way you reach it under the UAA and now in most states' laws is what is defined as a test. And the trick is that, and I know I'm repeating some of what Barry spoke about this morning, but just to recap, highlight, currently the definition of a test, and therefore the definition of things which only CPAs can do, and indeed CPAs can only do through CPA firms, registered CPA firms. They refer to the engagements under SAS, engagements PCAOB standards, SARS with regard to compilations, and the SSAE with regard to prospective financial information. When the SAS 70 services were moved over to SSAE, that fit, there was a lot of logic to it. The problem was that those were not necessarily services that were with regard to prospective financial information. So some of what we're talking about there are things that were traditionally regarded as things that only CPAs should be doing. They were part of a test. And simply by moving them to a different set of standards and not pertaining to future financial information, they suddenly became unintendedly outside the definition of a test. Setting those aside, there are a number of other types of services that are covered by SSAE, and I'm going to back out of your question, if I can, the word report, because the word report may or may not be tied to the type of service. Whatever the end result is, it might be something else. But the key in the definition of a test is whether or not someone is purveying those services and saying that they're doing so in compliance with applicable standards. And if they're doing so and they're not a licensee, there are already some ways that you can address that are set out in the UAA in terms of the use of the title or similar professional designations that give that impression that you're performing an assurance service. But the key is going to be is whether or not the public is being misled into thinking that they're getting something from a competent professional who has been trained to render that type of service and is required not only by their training, but also by laws and rules to be performing it pursuant to those standards, and that if they don't comply with those standards, then they risk losing their license altogether. So there's a catch there in that there has to be more to it. The other thing in the definition of a test right now, it's prefaced with relating to financial statements, and one approach to that is removing the reference to financial statements and keep it broader than that. There's always a risk that if you over-regulate, you can be challenged perhaps under state constitution. There's a strongly held position that if the state adopts it by statute, that there's a thing called state action exemption, and it's not subject to any trust challenge, but it might still be there. Separate questions whether or not an individual state's laws, it might be subject to challenge. You don't want a lawyer answering your policy question of that, but we're in the process now of identifying cases in which members of the public were actually harmed by someone providing one of these other SSAE services, but were harmed by someone who was not regulated, someone who was not a CPA. And there are instances out there.
Thank you very much. Appreciate it, Noel.
Sure.
Okay, no. If a CPA is ordered by a federal agency to disclose information, must he or she first let the client know?
Well, you would have to look under the state's laws and rules. And there are only a handful of states that really actually require notice. Almost all of the UAA and the state's rules with regard to confidentiality all have an exception if you are served with a subpoena or other government process. And unless you built in a separate a requirement that the client still receives some sort of notice, then literally CPAs every day have to turn over information with regard to, in response to a subpoena, even if their clients don't know. I have a fundamental problem with that, and we're trying to address it in the UAA, and that is that the world has changed. When the standard was drafted, the ethical rule, and then the UAA was drafted, this idea of having an exemption for a subpoena seemed to make sense, and that is the court's telling you turn over this document. But under modern practice in most states, the rules of civil procedure provide that if someone is the process for getting a subpoena is minimized. In fact, if I had a piece of paper, if I had the right form up here, I could issue a subpoena on any view, assuming I was in the right state and licensed here. But and there's a concern that it might not even be with regard to a pending action. So there's potential for abuse. And if you're involved in litigation and you want to make life difficult, and even though you have no interest in what the subpoena, what the CPA might have, one way to bring pressure about and to do it without the client ever knowing is to subpoena those records from the CPA. If the feds are dropping that subpoena or that summons upon you, as a grand jury, you may not only not have an obligation to let the client know, you might have an obligation not to tell them. And so I think there's some interest in bringing into the rules a notice requirement to give the client a reasonable chance to interpose, to object to the subpoena, to the discovery as might be appropriate. The important thing in that is not to shift the burden of defending the subpoena over to the CPA, but to put it where it belongs, and that it's the client and the client's records. And if they have reason to believe that the subpoena is inappropriate or that they're privileged, then they can fight it, but give them a chance to.
Okay, let me ask you, if a CPA received a notice to turn over records they received that notice on Monday and they got to turn the records over on Tuesday, what would you advise the CPA to do to a federal agency?
Absent a state rule, you are in a bit of a pickle, and you turn over those records unless you want to suddenly go from being someone who provides information to someone who is the target of the investigation and withholding information. There are exceptions, and one thing that one might consider doing, although I'm reluctant to put it in place as a regulatory burden on the CPA. I think the objective is protecting the client records in a reasonable fashion. But one option that a CPA might have is to, and this has occurred in many states, is they receive the subpoena, and so they will at least initially inform the court that they've received the subpoena, but that this other rule prohibits them from complying without first notifying their client. And if you have that rule in place, you can use that, and a court will at least hold things up until that issue of whether or not the client has had an opportunity to object is resolved.
Okay, on public records. If you'd answer these two questions that I'll pose at once. First, back to Things for Dummies, what is a public record? And second of all, and I'm talking about public records that boards would have. What is a public record from the board's point of view, and would correspondence or communication to and from the board with NASBA be considered a public record?
Okay, well, I know from your tenure in the Louisiana board that I'm not talking to anyone who needs public records for dummies. But obviously, every state has some degree of public record statute. Many state boards have exemptions with regard to certain of their records in it won't be in the public records statute, but it'll be in their own accountancy act. In general, and the philosophy behind the Public Records Act in the states is that if it was created in any way at government expense, received by a government entity, or another way pertaining in any way to the public business of an agency, then it is a public record unless there is some direct, clear, applicable exemption. It goes so far that in some states that the attorney-client privilege does not even completely extend over all public records. North Carolina is one of those states, and there are a handful out there where it becomes a public record 3 years after the litigation is over. And there are even angles on that, nuances amongst that as well, so that even if you communicated with your attorney thinking that it would be forever attorney-client privileged, it might not always be such. But again, there are exceptions out there. There's one that's laid out, I think, very well in section, I believe, 4 of the UAA, and I urge you that more and more you're going to see this kind of issue, and you need to address it, try to address it in your act, because making everything that you receive a public record arguably opens you to all kinds of exposure. Ask the state of Washington if you have any doubts about that. They had to cough up $500,000 at one point over a completely unusual and largely bizarre and ridiculous, I'd even say, situation. But the exposure is there. But build it into your statute so you've got some greater degree of protection, because otherwise it impairs your ability to conduct an investigation. As if you receive information and everything you receive is going to be a public record, all these communications with investigators are public record, it becomes a problem in terms of being able to effectively enforce. There are those that argue vigorously that the light of day is the best medicine for any kind of shenanigans in state agencies, but by the same token, if it impairs your ability to protect the public as opposed to yourself as a member of an agency, then you've got to look at it seriously. And again, many states have adopted this, and the UA has a provision that sets out that if you receive it in connection with investigation, then it's exempted from. It's not even considered a public record, so it's exempt that way. Recently, might be of interest to some of you, that North Carolina received an Attorney General opinion that went a little further and said that since the statute that creates this exemption also refers to not just simply disciplinary, but licensing and application matters, which again you can imagine you've had to follow up with an applicant with regard to a question about a criminal record or something like that. But they said that the AG said that since it encompasses application matters, then the email addresses that applicants provide in their application for renewal were not public records and therefore exempt from disclosure. So it can be taken to unusual links. And again, that's an AG opinion. I'm sure Bob Brooks or Frank Traynor can provide you a copy of that. I can too. But the core there, and again, the UAA, I think it lays out pretty well. The UAA provision also talks in terms of information that is provided as a consequence of an obligation to report. As many states, most states, in renewals or otherwise, or within 30 days, you have to tell whether or not you have been charged or convicted or even sued. A self-reporting matter would again be something under the UAA provision that would not be a public record. And so again, it becomes public record if you have to use it at a hearing, but otherwise would be protected in that regard. So that's kind of the interplay.
Okay. Any questions from the audience in that regards? Okay, confidentiality of board proceedings. Any thoughts to the question of when is confidentiality of proceedings appropriate, of state board proceedings?
That's one that depends on a different statute, and that's the open meetings law. Again, almost every state has an open meetings law, and those are typically talk in very broad terms and also explicitly say that disciplinary hearings and such are presumed to be in the public domain and should be open to the public as well. I think the narrow exception that's out there, and I know a few states have used this from time to time, is if, for example, there was a hearing over good moral character, and the character issue was whether or not, someone had been charged or convicted with regard to molestation or certain other offenses that where the witnesses themselves might need some degree of protection. In that instance, to err on the side of caution, you want to be sure that your record reflects a reason for having any part of the proceeding go into a closed session. It could not be a situation in which the defendant or respondent themselves was excluded. They would still need to be in there and have an opportunity to confront. It would just be taking the transcript and the proceeding itself out of the public domain, maybe reducing it a little bit in terms of being sensational or prurient, as it were. But even there, you would probably want to get a ruling or some clear signal or either statutory provision allowing for that extraordinary situation.
Okay. If the SEC takes action against a CPA or a firm, and under what circumstances should a state board take action to the question of piling on?
Piling on. Okay, that's not confidentiality here.
Oh, I'm sorry.
No, fair question. I've expressed concern over the years with regard to piling on, in part because of a sense of timing, in part because a state agency or a federal agency or another state's agency can get in the way of a fair result in a disciplinary case. Let me take the classic example I've used that's outside of accountancy but still makes sense, and that is that a few years ago, and my firm represents many state boards of architecture, including the North Carolina board, and there was an instance where one individual architect had undertaken a project in North Carolina. He had maintained his own individual license, but he had let his firm license lapse. Now, that tune might not sound so unfamiliar in this context in accountancy either, but the board said, okay, you should have kept you were undertaking an engagement. You in fact sealed work using your firm name. Therefore, we're going to slap you on the wrist. They allowed him to get registered ex post facto, but hit him with a $500 civil penalty, which he consented to as part of a consent agreement. In the consent agreement, it spelled out how he had violated the state's firm registration law. 3 years later, he comes back and he says, you know, that $500 civil penalty, I was licensed in 30 different jurisdictions, and I'm up to almost $50,000 in civil penalties, fines that I've had to pay to other states where nothing happened in their state, but the fact that I had violated another state's laws or rules constituted a violation in and of itself. And so based upon that, they had imposed, Pennsylvania was one that imposed, I think it was $10,000, you know, and again, unrelated to anything that had actually happened in that state. So I wonder aloud, if any of you try to do that, we will defend your right to do it, assuming the statutes are clear, but I wonder as a matter of public policy if that's such a great idea. In the accounting context, it relates more to things such as you know, what the PCAOB may do with regard to an inspection that they determined there were some real problems there. How far do we take it on a state basis? Now, don't get me wrong, because this is about public protection, and if your state has some direct interest in it or indirect because the firm is registered there, then you need to have the prerogative to be able to do something about it and protect your citizens, especially with regard to the individuals or the office of the firm that's been called into question by something federally. But on the other hand, federal enforcers will tell us that they will sometimes enter into these deals where $1 million fine is paid and they're cited for various things, but they don't have to admit any wrongdoing because they're confronted with the fact that if the discipline they impose is taken down to the state level, that licensees could, you know, that licenses and firm registrations could be impaired, and that the discipline that they intended that was narrowly crafted could take a life of its own and go too far. And they have trouble cutting their deal. That's the bottom line. They have trouble cutting their deal if they have to take into account what might happen at the state level. But what's happening more and more, and it really is a good idea, is that if you have a violation of federal law, a finding of violation, a consent order or discipline imposed by a federal agency, it should be automatic and shouldn't have to retry the case. But at the same time, there has to be at some point some prosecutorial discretion, some way of determining whether or not the interest in your state is direct enough to justify the additional action with regard to the office or the individuals or the firm. Again, a balancing act, but it's a problem. Courts have upheld this notion of piling on, of two states imposing discipline over one act and very disparate types of discipline. So it's probably going to continue to be legally defensible, but at some point in time, we run the risk of getting in the way of each other. If you are trying to, imagine again in North Carolina, the architect situation, we never would have gotten a consent if he knew that around the corner he was looking at $50,000 worth of civil penalties around the country. And so it can impair a fair and simple solution. And all of us face caseloads that imagine if you had to take twice or 5 times as many going all the way to hearing simply because the stakes were so large. In an era of mobility, two things are going to be very important. One is that you communicate and that the bad guys from jurisdiction to jurisdiction, you know about them, that the licensee database works, and you can protect your citizens. At the same time, that simple, non-moral turpitude type of offenses don't grow out of proportion simply to help, sometimes, revenue in a state that otherwise has no interest in a particular alleged wrongdoing. So it is going to call upon greater sense of responsibility among all of us to make sure that this doesn't get out of hand. Otherwise, it's something that's intrinsically in interstate commerce, and questions could be called even federally, especially if they feel that these things have a way of growing and becoming a problem or an impediment to their resolving cases on a federal level. Again, I give you no answer. I just say it's another balancing act. I apologize for that, but those are the important, tough calls.
I understand. Any questions from the audience for Noel or Michael? I do have one final question for Noel, if you don't mind. At the regional meetings, you scared us all to death with the story, if you will, of the court's attack on the dental board that had tried to restrict the services of a non-licensed dental whitening business. And if you could just take 2 minutes to give us any sort of update or refresher on that, that would be great, and we'll wrap up.
Will do. This is a matter not involving a CPA board, but involving a dental board, in which the board was enforcing a statute which prohibited certain services unless they were rendered by a licensed dentist in that state. And the board sent out cease and desist letters to some alleged illegal operators. The Federal Trade Commission stepped in, and this is what you worry about. There were two parts of their theory. You remember I mentioned earlier state action exemption. They have announced in policy documents that they want to attack the state action exemption, that even though Congress has not changed anything, they want to attack it, and they want to trim it back. You talk about Texas and how they protect the public in terms of what they prohibit as far as use of even the term accountant. Other states that have restrictions on practice. The FTC, pursuant to that, has took two theories to the limit in the North Carolina case. First of all, I should add, the hearing, they drugged the board to Washington, D.C. for 5 weeks of hearing. How many of you have that in your budget? All right. And so it doesn't matter. They'll get you there no matter what. But their theory was that state action didn't apply, that the board members, because the majority of the board were licensees, that it was an ipso facto antitrust conspiracy. Now, if that prevails, it'll be a very different audience here next year.
So is there any follow-up as far as the dental board trying to protect that?
Sure. I guess where it stands now is, as we fully expected, the FTC, which is a court of its own, ruled in its favor that it had jurisdiction, that its theories were good. By the way, the other prong of their approach was, and this is an agency whose motto is protecting American consumers, it ruled that public protection was not relevant. That there was no defense to this illegal restraint of trade. And so that's all on appeal. It's now pending before the Fourth Circuit. And I think the consensus is that whoever loses will be taking it on to the Supreme Court. There are amicus briefs that have been submitted on behalf of many combined state agencies, Federation of Federal Association of Regulators submitted briefs, the ADA, the AMA, all submitted Friends of the Court briefs in support of the state board's position. So it's teed up. I argue it in the beginning of December, and we'll keep you posted.
So does the dental board have the resources to do that?
Well, it's one of those that has the quasi-independence and had a reserve that was specified for defensive litigation. It ain't cheap, and they are caught in another crossfire. We're not involved in other litigation, which is sort of the perfect storm, I guess, in terms of your defense. But they have had the resources to fight it. Regardless, we're committed to helping them to the end, one way or the other. But it ain't cheap. It ain't cheap.
All righty, very good. Thank you, Noel, and thank you, Michael.
Thank you.